Defenses to nuisance. Defenses to nuisance are legal grounds available to the defendant to justify or excuse the interference complained of. Even if an act appears to cause nuisance, the defendant may avoid liability by proving that the act falls under a recognized defense. These defenses balance individual rights with lawful use of property and public interest. They are frequently asked in LLB examinations. Prescription. Prescription is a defense where the defendant has acquired a legal right to continue the nuisance by long and uninterrupted use. If a nuisance has been enjoyed openly and peacefully for a long period, the law presumes consent of the affected person. Under Indian law, continuous enjoyment for 20 years gives rise to this defense. The use must be as of right and without interruption. Case law, Sturges v. Bridgman, 1879. Facts: the defendant used noisy machinery for many years in his confectionery business. The plaintiff later built a consulting room nearby and complained of nuisance due to noise. The defendant claimed long use as a defense. Held: the court held that prescription did not apply because the nuisance became actionable only when the plaintiff started using his consulting room. Long use alone does not create a prescriptive right unless it causes nuisance throughout the period. Statutory authority. When an act causing nuisance is authorized by statute, the defendant is not liable provided the act is done without negligence. The law presumes that the legislature has authorized the inevitable consequences of such acts. However, negligence in carrying out the statutory duty removes the protection. This defense protects public utility and development activities. Case law, Vaughan v. Taff Vale Railway Co., 1860. Facts: sparks emitted from a railway engine operated under statutory authority caused fire and damaged the plaintiff's property. The railway company followed all statutory safety requirements. Held: the court held that the railway company was not liable as the nuisance was an inevitable result of a statutorily authorized activity carried out without negligence. Act of God. Act of God is a defense where the nuisance is caused due to extraordinary natural forces beyond human control. Such events must be unforeseeable and unavoidable even with reasonable care. Ordinary natural events do not qualify. Human intervention must be absent for this defense to succeed. Case law, Nichols v. Marsland, 1876. Facts: extraordinary and unprecedented rainfall caused artificial lakes on the defendant's land to overflow, resulting in damage to the plaintiff's property. The defendant had taken all reasonable precautions. Held: the court held that the damage was caused by an act of God. The defendant was not liable as the event was extraordinary and beyond human control. Consent of the plaintiff. If the plaintiff has expressly or impliedly consented to the nuisance, he cannot later complain about it. Consent must be free and informed. Mere knowledge of nuisance is not consent unless acceptance is proved. This defense is based on the principle valenti non fit injuria. Case law, Kiddle v. City Business Properties Limited, 1942. Facts: the plaintiff knowingly occupied premises near a noisy business and later complained of nuisance. The defendant argued that the plaintiff had accepted the condition knowingly. Held: the court recognized that where consent is clearly established, the plaintiff cannot claim nuisance. However, mere awareness without acceptance is not sufficient. Reasonable use of property. A person is entitled to make reasonable use of his property even if it causes some inconvenience to others. The use must be ordinary and lawful. Minor discomfort or inconvenience is not actionable. Courts balance the rights of both parties while applying this defense. Case law, Bamford v. Turnley, 1862. Facts: the defendant carried out construction work on his land, causing temporary noise and dust to neighbors. The activity was lawful and for improvement of property. Held: the court held that reasonable use of land for ordinary purposes is not nuisance. Temporary inconvenience does not give rise to liability. Plaintiff came to the nuisance. This defense argues that the plaintiff moved into an area where the nuisance already existed. However, this is not a complete defense by itself. Courts consider the nature of locality and reasonableness of interference. Prior existence alone does not justify nuisance. Case law, Miller v. Jackson, 1977. Facts: the plaintiffs built a house near a cricket ground and later complained of nuisance due to cricket balls entering their property. The ground existed long before the house was built. Held: the court held that prior existence of activity is relevant but not a complete defense. Reasonableness and public interest must be considered. Conclusion: defenses to nuisance ensure that liability is not imposed unfairly where interference is justified by law, necessity, or public interest. They help courts balance individual property rights with lawful activities and social needs. Understanding these defenses is essential for answering problem-based questions in nuisance under the law of torts and is highly important for LLB examinations.